Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On November 14th, 2024, Mr. Kohberger filed 13 motions to suppress. The second we are looking at today in our special part series is the motion to suppress the information obtained from his Amazon account. He says here on page 1 that he wants all of the data found by law enforcement from its search of his Amazon.com account suppressed, meaning having that evidence thrown out. He goes on to state that he has a privacy interest to his Amazon account under both the Fourth Amendment to the United States Constitution and the Constitution also of the State of Idaho, which prohibits illegal searches and seizures. And so he's arguing constitutionally that this was an illegal search and seizure. And if you read the memorandum, and I've provided a link so that you can go to the court docket and read it for yourself, he goes on for several pages offering argument, case law, and so forth as to why this search was, in his opinion, illegal. He is also, however, incorporating arguments from his Franks versus Delaware pending motion. A Franks motion requests a hearing from the court, and it attacks the warrant affidavit as being illegal, as either having reckless or intentionally omitted material and information. And we see this language on page 2 of this motion and thereafter. So what a Franks motion does is to attack the warrant affidavit. A motion to suppress is to suppress the evidence seized from a particular search. Two different arguments. Franks, much higher legal standard. Those hearings are rarely granted, and motions to strike affidavits and warrants even more rare yet. But there is a potential fatal flaw here in Mr. Kohberger's motion to suppress, as he says at the top of page 2. The motion and documents in support of a Franks hearing are hereby incorporated. That means instead of having a standalone motion to suppress, he is extracting information from his November 14th, filing requesting a Franks hearing and the exhibits thereto, and bringing them in here as if they were fully set forth herein. Problem being that 8 days later, Judge Hippler entered an order striking that first filing, that first request for a Franks hearing, and he gives his reasons. And if you read that order, if you go to a footnote 1 of that November 22nd order, you'll see the court describing this massive filing with 2,000 plus papers and having duplicative items repeated, no specificity pointing the court to where the defense is asking the court to look to try to determine whether or not he's entitled to this Franks hearing. And Mr. Kohberger, bottom line, was given 4 days to refile, which he did. So he refiled his operative Franks motion and support exhibits, memoranda, which sounds like it was a much more pared down filing than the first, on November 26th. So number one, there's no longer a motion that this motion to suppress exists anymore because it was stricken from the record. And number two, looking at the docket, Mr. Kohberger never moved to refile and amend this motion to suppress to bring it up to speed to conform with the refiled Franks motion. Or secondly, to just take out all Franks information and go ahead and submit what he needed to submit in terms of argument and exhibits on its own in an amended motion. So we'll see how Judge Hippler ultimately rules on this matter. If you would like to review these documents, go to the link that I have provided in this podcast description, and you can do so for yourself. This is Kathy. Thank you as always for joining us here today.